Who is in
Okay,
court?
my lord, parties are present, my lord.
Appearances. Say that again, louder, please. Okay. I can see we have 9 participants. Parties and counsel, if you are not for this matter, KTV and Ibrahim Ahmed, please leave the meeting. Hello? If you are not for this matter, counsel and party, if you are not for KTV and Ibrahim, please leave the meeting so that the connection can be better. Go ahead. Layman counsel.
Respectfully, my lord, A.O. Idris.
Yes, A.O.
Idris. For the claimant.
Okay, I got that.
Yes. May I please, my lord? Quadri Adirogba for the first and second defendants.
Okay.
Yes. My lord, sir, the matter is for continuation of trial. The claimant's witness is still in the box. However, sir.
Yes, go ahead.
My lord, the claimant witness is about to join. However, my lord, I just want to crave the indulgence of my lord that the claimant's witness, due to her condition, she said to me that she has a doctor's appointment. So I wouldn't know how long this examination is going to take. So I just want to put that in record. So in any case, we might seek an adjournment if peradventure the cross-examination is not done in time. She has doctor's appointment in the next 1 hour. So I don't know if that will suffice.
I believe your lordship gave the defense a time frame, and we have just very few questions. Very few questions. So we won't be occupied left.
Okay.
When my lord, we found letters, sir, before your lordship. The letter is dated 25th of May, 2026. And we also served the claimant's counsel.
The letter is dated when?
25th of May, 2026, sir.
Okay. What is the letter about?
Yes, my lord. We are bringing attention to the court, sir, that the claimants, in their usual manner, have employed the services of the police to arrest the first defendant again. While this matter is going before your lordship, the first defendant was arrested in Port Harcourt, in his hotel, based on the complaint by the managing director of the second claimant. He was held at the police station and had to ring immediately.
And had to do what?
He had to ring his lawyers. We had to use every possible means to get him out of custody. All this matter is and that's why we filed a letter bringing to the attention of the court such impunity on the authority of this court.
Mr. Idris, what do you have to say to that?
Very well, my lord. We received the defendant's letter, my lord. However, my lord, the claim of the defendant is totally inaccurate, my lord.
Okay. So what's the position?
My lord, the complaint before the Nigerian Police Authority borders on criminal investigations. And the claimants put a complaint before the police, even prior before the commencement of this case. And my lord, I believe a civil claim is different and cannot stop a criminal investigation. Why, my lord? It is possible that the same situation might have arisen from different set of facts or the same fact. My lord, the waters of the criminal investigation or arrest might run in the same water of the civil action before this court, but their water do not mix.
Say that again.
I'm saying, my lord, that the situation that arises might give rise to a civil action as well as a criminal action. But their water do not mix. As very well observed by the defendant's counsel, that there was a complaint of criminal allegations upon which the Nigerian authorities have so acted. And I believe that since the defendant's counsel brought this letter, they also have equally attached the criminal complaint. So that the court can be properly guided. So, my lord, the simple truth of this allegation is that whatever the defendant is facing with the police investigation has to do
has to do with what?
Has to do with criminal allegation.
Yes.
Which may have arise probably in the course of their employment with the claimants. Not testify, I'm addressing the court. That's why I said we might. I'm choosing my words carefully. So, my Lord, our simple submission is just that the criminal aspect is different from the civil aspect. The defendant can face their criminal allegations separate from the civil suit before this honorable court.
Yes.
That's our humble submission.
Defense counsel.
My Lord, sir, I believe as counsel in the Ministry of Justice, on Temple of Justice, rather, we owe the court the duty to be open and honest. My Lord, around February last year, this same claimant filed a complaint against the defendant.
Take it easy, I'm writing.
I'm so sorry, my Lord.
You said in February what year?
Last year,
Okay.
at Zone 2 Police Station, the defendants were arrested last year. They had to secure their bail. They attended the police station more than 6 times.
Are you also testifying now?
That's a matter of fact.
Are
Yours was speculative.
Are you also testifying now?
I know.
And then you have to do
As they got in front of the court, sir, the claimants without processes of this court in police station. The defendants were never charged. From last year, over a year, they've never been charged for a single thing. The same claimant again, while this matter is pending before the court, went to instigate the police in Port Harcourt to arrest the defendant again. And our position is clear, sir. They've brought us to court. We are all before your lordship. We should all wait for the outcome of your lordship. If they want to charge the claimant for any criminal offense, they should go ahead and charge. They cannot be employing the services of the police to intimidate the defendants. What the matter is before this court, sir? It's not done. And we shall apply before your lordship, sir.
You should apply for what?
My lord, sir, we shall be applying for your lordship to give an order to restrain the claimants from further engaging the services of the police to intimidate the defendants while the matter is pending before your lordship. We should all wait for your lordship's judgment. That's our humble approach.
My lord.
Go ahead quickly.
Yes, my Lord. The defense counsel is making some allegations on facts. And he has no affidavit or sworn written statement on oath before my Lord to justify the fact. And my Lord, sir,
Yes, go ahead.
allegation of claimant instigating the police to harass or intimidate the defendant
Yes.
is, my Lord, I want to maintain, totally inaccurate.
Yes.
My Lord, what is before my Lord is a civil action. What the police authorities are treating is a criminal investigation. It's not our duty to charge them. We are not the police. Then you can go and appoint the police to charge them. My Lord, we don't have the power to
Yes.
compel the Nigerian police authority to charge the defendant. But my Lord, I believe it is within the constitutional right, duties, responsibility of the claimants to lay a complaint to the authority without fear or favor.
Yes.
While it is within the domain of the Nigerian police force to decide on their own to carry out criminal investigation and or with or without arrest. Probably the defendant counsel would have helped this honorable court since they claim they are aware of the matter and they pool all their resources to get out the claimant at Port Harcourt. They could have availed this honorable court. The criminal complaints. You are the one that is bringing us here. Raising it. Bring it. Avail this court the said criminal complaint to see whether or not
Yes.
the honorable court can sue motu made an order to prevent the police from carrying out their statutory duties. My Lord, in summary, all the allegations of intimidation, harassment is totally rebutted by the claimants. They are untrue, they are inaccurate, and made malafide calculated to mislead this honorable court. That's our humble submission. And we pray, my Lord, to refuse that application for lacking in merit.
Claimant counsel, what you have to say again? Defendant counsel, sorry.
Yes, my Lord, we just have one because I believe time is of the essence. I
Yes.
believe Lordship is an arbiter. Your Lordship is here to do justice, and it is the duty of the court to do justice. The claimant's counsel said that I made statement of fact. Your Lordship can swear motu, sir. In these proceedings today, ask the witnesses if what transpired was true or not. There are many authorities in that regard. And what we're saying is simple. They brought us to court. Let the court do its job. They ought not to engage the services of the police to intimidate the defendants.
If not,
This is the second time, sir. Over a year ago, they filed a complaint that got the defendants arrested. They rushed down to file this claim against the defendants, where we got involved. Suddenly, they decided to arrest the defendants again.
who arrested the defendants? The Nigerian police.
And your Lordship, sir, the Nigerian police didn't just wake up to go arrest the defendants. They were prompted to by the claimants. And your Lordship can, in these proceedings now, question the witnesses and ask them if that's the true case or not. Then we bring the petition, we bring the complaints to know who is lying or who is telling the truth. And your Lordship can find anybody in contempt. We urge your
Okay,
Lordship
I've listened.
to grant our
I've listened.
Yes, sir.
Okay. Okay, hello?
Very well, my lord.
Yes. So I've listened to both parties. What is before this court today is a civil complaint, not a criminal complaint. There is no affidavit of fact or a counter affidavit deposed to before this court. All the defendant has filed is a letter intimating the court of police harassment of the defendant. The Nigerian police force is empowered to carry out criminal investigation, and how they decide to carry out this investigation is not within the power of this court to determine. The criminal complaint is not before this court. There is no affidavit of fact to enable this court determine the true position of the matter. In the circumstance, this court shall restrict itself to the civil complaint before it, and at most, I make an order of accelerated hearing to enable the court determine the civil aspect of this case. This is the order of the court. We shall now go into the business of the day, which is continuation of trial.
As the
As the
court
court
pleases,
pleases.
you are most obliged, my lord.
Is the claimant online? Claimant
Yes, my lord.
witness
The
online.
claimant witness is online.
Registrar, remind her of her oath quickly.
Good afternoon, Mrs. Tatmau.
Good afternoon, my lord.
Do you remember you are still on note?
Yes, I do.
Anything you say in this court shall be binding on you.
I understand.
My lord, the witness was reminded of our oath.
Okay, thank you.
Yes.
So
Very
go
well.
ahead.
I noticed the video of the witness is not on, sir.
Yeah.
Very well. Thank you. Witness, I heard you have doctor's appointment, so I have just very few questions, and I'll be done.
Okay, thank you.
Yes. At the last adjourned date, you said the defendant resigned, right? Am I correct?
Sorry, I didn't get that.
At the last adjourned date,
Mhm.
in your testimony, you said the defendants, they resigned.
Yes,
Am
they
I
did.
correct?
Yes.
Did you pay any of them their gratuities?
The defendants were paid their whatever was due to them, salaries and thereabout.
So your answer is yes, the defendants were paid their gratuities.
I think the first defendant was paid his salary as at when due
Hold
because
on, take it easy. Hold on, take it easy.
Ms. Asmao,
yes,
okay, please, when I ask you the questions, so that we'll make things very fast, you
yes.
tell me yes or no. Then you can, I don't have a problem with you explaining. I don't.
Okay.
Say yes if you think they were paid and they were paid this. No, they were not paid. So everything will be
My
simple
lord,
for everybody.
my lord, I will object to that line of, you can't tell the witness how to answer your question. There are some questions that you cannot box it to a yes or no answer. You need to explain the context. So I think my lord should give the witness the free rein for her to explain herself. It's a matter of question of yes or no. This is a court of record. Whatever she said can be put on record. So you are not to tell her what to say. This is a fact. Please.
Ms. Asmao.
Defense counsel. Defense
Yes,
counsel.
yes, my
Ask your
lord.
question, and if she can answer yes or no, and she can also go ahead to explain.
As the court pleases, which is what I said. As the court pleases.
So she can go ahead and explain. Take a few minutes to explain why she said yes and why she said no.
I'm okay with that. So did the claimant pay the defendants their gratuities after they resigned?
I believe so. They were, as long as they fulfill their resignment conditions per company policy.
I'm sorry, I don't understand what that means. Are you saying they did not fulfill their conditions It's like that's why I said it's a yes or no. Were they paid or were they not paid? You can't be in between. They were either paid or they were not paid.
Witness,
Yes, my lord.
the question is quite straightforward. Did you pay the defendants any of their entitlement? If you paid entitlement 1, you say so, or entitlement 2, you say so. Let's move on, please.
Please.
At the time the first defendant resigned, he gave adequate notice of resignation and he was paid what was due to him.
Hold on. Because at the time the first defendant resigned, he gave adequate notice and he was paid what was due to him. That's your testimony, right?
Yes, my lord.
Okay, how about the second defendant?
As for the second defendant, he did not fulfill the adequate notice condition in the company policy that required him to be paid his last salary.
Defense counsel, go ahead.
As the court pleases, I believe that answer is clear. So the first defendant was paid, but the second defendant was not paid according to your testimony.
Yeah, go ahead.
Okay. Miss Asmao, is your email address, please confirm yes or no. Is your email address asab@angaroadinternational.com?
Yes.
Okay.
Yes, go ahead.
Who is Franklin Masade?
Come again.
Who is Franklin Masade?
Franklin Masade is an employee of SEPNA.
Employee
That's
of what?
Seplat. An
Seplat.
employee of Seplat. Seplat, yes.
Go ahead.
Is he involved with the contracts you spoke about at the last proceedings, at the last adjournment? The contract of MPNU, which you spoke about?
Yes. He's an employee of Seplat.
Okay. My lord, we have an email which we wish to tender through this witness, sir. The email is attached to our defense. It's an email which emanated from the witness. They shall copy of the.
So we have an email which we wish to tender, and it is what?
Through the witness side, an email that emanated from the witness.
Okay.
From Miss Asmao Abdul Hamid. I don't know if she has a copy of the email. The email is dated Monday, September 9 to one Mr. Masade.
Monday, September 9th, what year?
September 9th. I'm trying to check for the exact one. At 8:12 p.m.
Yeah.
I'm trying to check for the it's faint here. My lord, please let me check. My lord, I can't specifically find the here now. It's a bit faint, but I'll come back to that, my lord. The year is 2024, my lord.
So it is dated Monday, September 9th,
2024.
2024. Okay. It was sent at what time?
8:12 p.m.
8:12.
Yes, p.m.
Okay.
Mm-hmm. Go
I don't know
ahead.
if you have a copy. Witness, do you have a copy of all the exhibits before you?
Was it front loaded?
It was front-loaded, my lord.
I would
Do you
have
have
to
a
search
copy?
through all the documents I have to.
Okay, let me make it easier. I want to read from the extract of your email. The email emanated from you.
You have not even tendered it, and I can't allow it.
My lord, we wish to tender this email into evidence, sir.
Registrar. Registrar.
Yes, my lord.
Do you have the exhibit file there?
Yes, my lord.
Okay. Claimant counsel, do you have something to say?
Yes, my lord.
Go
My
ahead.
only comment is that the email sought to be tendered, though it's an electric generated evidence. We don't know whether proper compliance has been done in respect of this particular email. So that we can be sure that the email sought to be tendered is what you want to tender. No, it's there. It's concluded. The document that you want to tender is in you. What if it's the pen? Let me have it. It should be this one that you want to tender.
Claimant
So,
counsel.
my lord, yes, my lord, I'm saying that the email sought to be tendered appears to be an electronic generated evidence.
Mm-hmm.
And to the best of our knowledge, and according to the Evidence Act, it ought to be accompanied with a compliance certificate. More as well, since they wish to tender it through our own witness. And that is not done in this case.
Okay, I've noted that.
As the court position.
My lord, sir,
Yes, Mr. Kwadiri.
attached as a loaded exhibit is a certificate of electronic generated evidence pursuant to Section 84(4) of the Evidence Act, sir. Every listed electronic evidence is in that certificate. And the claimant's counsel was filed with this document as well, but served with it because it was front-loaded.
Can you pass the
Yeah.
certificate of compliance? Hold on. Can you pass the certificate of compliance to the claimant counsel to look at it quickly?
The date is Monday, September.
No. Hold on. Evidence of the claims field meets contractual obligation.
Is this what you mean? My lord? My lord,
Yes,
sir?
yes,
So
I can
what
hear you.
I read this.
what the
They said the
defendant counsel is showing me in their certificates of compliance, which is dated the 15th day of September 2025, number 10 is what is termed as evidence of claimant failure to meet contractual obligations. Wait, now I'm still addressing.
Let me see your uncle.
So what they mention is evidence of claimant's failure to meet contractual obligations.
In the last paragraph.
This can mean any evidence. It was never indicated what evidence. As far as I'm concerned, my lord, it might be a video evidence, a photograph, so I think, my lord, the essence of the compliance is for anyone to look at the document and be able to say, this is the document we are referring to. So, my lord, the description, evidence of claimant's failure to meet contractual obligations. My lord, it doesn't suffice in any way to show that this is the document they are referring to. My lord, the email sought to be tendered is dated from the claimant and from the defendant counsel is dated Monday, September 9, 2024, which was sent at 8:12 p.m. At least there should be these particulars about the documents sought to be tendered. My lord, it's on this basis I want to pray this honorable court that the said certificate of compliance that the defendant wished to rely on in fulfillment and compliance of Section 84 of the Evidence Act is grossly deficient and insufficient, and it does not meet the standard required by the Evidence Act. On this basis, I urge my lord to mark these documents as tendered but rejected. Very well, my lord.
Yes, defense counsel.
Yes, my lord. My lord, if your lordship goes further in the certificate, which was front-loaded, it states here which emails and letter of correspondence were conversations between the first claimant, second claimant, and it details it. It details where it was.
What paragraph is that?
My lord, is the paragraph just before paragraph 3 at the end. at the end, which email and letter of correspondence are. It even says in paragraph 4 where it was printed, the computer which it was printed, the printer in which it was printed. In any event, sir, the guiding rule for admissibility of evidence is relevance. How it is relevant to the case. At best, sir, and we can punish your lordship with various Supreme Court authorities. At best, sir, your lordship can even order that another certificate should be filed. If they are not, that's assuming we're not conceding that this certificate is not up to, which we believe it is. It fulfills the requirements of the Evidence Act because it mentions that the emails and where it is printed from. But at best, your lordship can order that another certificate not to reject or mark the document as tendered and rejected, because the guiding principle for admissibility is relevance. Accept it. Are you replying on point of law? If you want to go on evidence article and rules, you have to rely on point of law.
You know what's going to happen? I'm going to admit this document under protest.
At the court basis.
At the final written address stage, you can address the court on its admissibility or not.
As the court
As the court pleases.
As the court pleases. I'm most obliged.
Okay. Mr. Small, can you hear me, please?
Yes, I can hear you.
Yes. At the last adjourned date, you said the witnesses jeopardized the contract of the MPNU. Am I correct?
Hold on, let me mark that document. Kadijat,
As the court pleases.
is this the first document being tendered by the defendant counsel?
Yes, my
Mr.
lord.
Idris, this is the first defendant. Okay.
Yes.
Yes, my lord.
Yes.
So email dated 15 September 2026.
My lord, 2024.
2024, my lord.
That's our
The date.
issue with the document. It's not, it cannot be properly identified. Tomorrow they will come with another sort of email to also say that they have updated.
So email dated 15 September 2024 is admitted and marked as Exhibit D1 under protest.
Your lordship said September is 9th September, my lord.
You see?
So that, hold on.
It's
What
9th
is
September.
on that
It's on the face of the
email?
email.
What is the date on the email?
9th September, Monday, 9th September 2024, 8:12 p.m.
Okay.
Is this your case?
So email dated 9 September 2024 is admitted and marked as Exhibit D1 under protest.
D1 under protest.
Okay.
Yes, at the last adjournment.
Just a minute. Counsel and party, if you know you are not for this matter, Care TV, please leave the meeting.
Okay.
If you know you are not for this matter, Care TV and Ibrahim
I'm
Ahmed,
not.
leave the meeting. Defense counsel, go ahead with cross-examination.
As court pleases. At the last adjourned date, you stated that the defendants jeopardized the MPNU's contract. Am I correct?
The project, yes.
Yes, I'm correct. Okay.
MP what?
NU.
NPNU.
Yes, my lord. She stated it at the last adjourned date, sir.
Yes. She said yes. Go ahead then.
Okay. I want to read from the second paragraph of your email. This email emanated from you to the Mr. Masade. Are you listening, please?
Yes, I'm
Is it a
listening.
long paragraph?
Okay. Paragraph 2, sir.
Is it a long paragraph? I don't have time to read a
Is
long paragraph.
I'm just going to highlight some in paragraph 2.
Okay, quickly
where
do
she
that.
said, as you are aware, the project has experienced significant delays since we completed T5506, largely due to MPNU unplanned activities. Then she said, while some of the initial delays were expected, as this is the first time HRI is executing a multi-stakeholder project with MPNU.
So what is the question?
The question is, sir, according to this email, which you sent to MPNU, you stated that it was MPNU's fault that there were delays in the contract. These are your words. While some of the initial delays were expected, as this is the first time HRI is executing a multi-task stakeholder project.
My lord, reading from the email, I don't see where the witness stated that the delay is the fault of MPNU or whatever. So if counsel wants to ask a question, having quoted what he has, he can ask his question. I don't think he's entitled to put words which were not the words of the witness to her mouth. Ask your questions. Not for you to be putting what you want to the mouth of the witness. Thank God there's a document before you. If you want us to read, we'll read, and then we'll answer the questions that is coming out from there.
My lord, I'm confused as to your question of claimant's counsel.
Defendant counsel, please go straight to the question. You have
As the court pleases.
tendered that document. Go ahead and
According
ask
to
the
this,
question.
yes, ma'am. Yes, my lord. According to this, your email, what did you mean when you said, while some of the initial delays were expected, as this is the first time HRI is executing a multi-stakeholder project? And what did you mean when you said that the delay was experienced due to MPNU's unplanned activities?
Okay. I will start with your question where you said unplanned
Hold on,
delays.
witness. Hold on, witness. I'm writing. Okay, go ahead. You say what?
My lord, please, my lord, one second, please. Let me rephrase the question, please.
I
So it
understand the
will be
question
easier.
perfectly well.
No, I want to rephrase. I have a right to rephrase my question.
Okay, rephrase your question.
As the court pleases. When you said that there was experienced delay due to MPNU's unplanned activities, did you mean that MPNU delayed the contract, delayed the project?
No.
I didn't get that question, defense counsel.
According to her
When you
email,
said,
where
listen
she
to what I
said,
have, listen to what I have recorded.
as
You
the
say
court
when
pleases,
you said there was experienced delay due to
yes,
NP what?
MPNU's unplanned activities.
Okay.
Am I correct to say that you meant MPNU delayed the project?
Witness, answer the question. Did you get the question?
No. Yes, I did, my lord. No, that is not
Okay,
what I mean.
Okay.
Okay. You also said the initial delays were expected this is the first time HRI is executing a multi-stakeholder project with MPNU. You also said that in the email. According to that statement, did you also mean that the project was delayed due to HRI being the first time they were engaged in a multi-stakeholder project?
No.
Okay.
That is not the first time HRI is engaged in a multi.
I just read from your email. I read from your email. I didn't conjure it. This is what the email said. Witness. While some of the initial delays were expected, as this is the first time HRI is executing a multi-stakeholder project with MPNU.
Yes, you didn't say with MPNU. That's why I said no, this is not the first time. With MPNU.
With MPNU. So this is the first time with MPNU, right? The project we are talking about is with MPNU.
Yes.
So, but this is the first time you engage in a multi-stakeholder project with MPNU.
This is
Witness,
the
is this the first time?
My lord, I'm trying to clarify. This is not the first time we're working with MPNU, but yes, yes.
That's what I asked. This is the first time you are executing a multi-stakeholder project with MPNU. That's what the email says. I didn't conjure this thing. It's what you wrote.
Yes, a multi-stakeholder. I'm trying to clarify, counsel. A multi-stakeholder, yes, but that is not the first project with MPNU.
Also, in the email,
hold on. So this project, NPNU, this is the first time you are executing a multi-stakeholder project. Is that correct?
Yes, my lord.
Now I'm asking the witness.
With MPNU, my lord, with MPNU.
I'm asking the witness. Let the witness answer.
My lord, that was what I was trying to clarify, but he doesn't want to allow. I was saying this is not the first project we're executing with MPNU, but a multi-stakeholder.
Hold on. Your answer is no. This is not the first
project with MPNU.
But what?
But this project of robotic inspection, yes. This is the first time that HRI is carrying out multi-stakeholder robotic tank inspection project.
My lord, I protested that because this is a lot of wordings. What I asked was, is this the first time that HRI executed a multi-stakeholder project with MPNU? And she said the first answer was no. The answer is yes. According to the email, and she has said it now. Yes, this is the first time HRI is engaging in a multi-stakeholder project with MPNU.
But you can, hold on, counsel. You cannot put words. Hold on, counsel. You are not in the box. The witness is in the box, and the witness is supposed to testify. So it is what she testified that the court will record. If you have anything to object, you can address the court on your final written address. But to insist that that is not the answer, I don't understand what was going on here.
No, my lord, she said an answer before. Then she changed the answer when your lordship asked the question again. My lord, that's what I wanted to clarify. That is when I asked, hold on, please. I'm on my feet. When I asked that, is this the first time HRI is executing a multi-stakeholder project with MPNU? She said yes, but this is not the first time HRI will execute a project with MPNU. That was her answer. Your lordship asked the question, then she remodified it.
My lord.
And that's why I objected to it.
My lord, even from what the counsel just said now, I think I got the gist of the whole matter. The question you are asking, the witness tries to clarify, and from what you just said now, it's exactly as what she has just said. This is not the first time that HRI is executing project with MPNU, but the project of multi is the first time. So it's just trying to show that there has been a series of engagements. Sorry, my lord, that there has been a series of engagement with HRI and MPNU.
You can't be.
But this multi is because I'm still on my feet.
He's explaining our answer.
I'm still on my feet.
Your Lordship is explaining the answer.
I'm
If you
still on
want
my
to enter
feet.
the box, you should enter the box.
I'm still on my feet. My Lord, I believe that counsel asked this question because he is unclear as to the meanings of what that document states. So it's not on him to box the witness on what to say. He's asking for an explanation and clarification, which the witness is given. So if you are not satisfied with it, then you leave it like that. This is a court of record. You are not the court. The court takes its record. Whatever the witness says, the witness is bound by his own statement or her own statement. I believe your question is because you didn't understand what the witness put in black and white. That's why you are asking the question. And the witness has explained what she meant by what is stated.
That's not true. What you just said now is not true.
Even from the explanation you gave, is what I even have on record here. Multi-billionaire is the first time, but there are series of projects which HRI and MPNU has executed together. Simple. That is a way to summarize it.
Defense counsel.
My Lord, I won't waste the time of the court. We'll proceed. According
Okay,
to the
let's
same
proceed.
Yes, my Lord. According to the same email, and I'm reading for the email which you sent.
Paragraph, please.
Paragraph 3. You said, unfortunately, we have now exceeded the number of work extension approved by the Nigerian immigration, and as a result, can no longer keep the experts in the country. Now, my first question.
Okay, that you're reading from what paragraph is that?
Paragraph 3, my Lord.
Okay. So what's the question?
Were expatriates involved in this project? Witness.
Yes.
Were expatriates involved in this project?
Yes, they were.
Go ahead.
Now, yes, you stated, like I read, that HRI has exceeded the number of work visa extension approved by Nigerian Immigration Service. As a result, can no longer keep the experts in the country. Am I correct?
Yes.
Okay.
Say that again. You also stated that HRI had exceeded what?
The number of work visa extensions approved by Nigerian Immigration, and as a result, can no longer keep experts in the country.
Yes, and she said yes.
Yes, my Lord.
Go ahead then.
Okay.
Go ahead.
My Lord, there's also one more email which we seek to tender. I'm trying to look for the exact dates. I'll come back to that. Let me not waste the cost time. Witness, am I correct to say that last year you submitted a complaint to Zone 2 police station against the defendants?
Yes.
What crime did you allege that the defendants were the defendants' offense?
There were several. I would have to refresh my memory from the documents because it's been a while.
As the court pleases.
It's not court that spoke.
Let the court.
Witness, are you going through your documents or what? What's going on?
My Lord, I'm trying to see if I can find a copy of the document because it's been over a year. I can't really remember exactly the subject, but I know it borders on criminal fraudulent activities.
Yeah, then we need to tell the court. You admitted that you submitted a petition against them.
Yes.
I think we can go ahead with that.
Yes,
As
was the
okay.
petition submitted after they resigned? After they resigned from your employment,
Sorry, come
is
again.
that when the petition was submitted against them?
I believe so, if I can recall. I believe so.
You believe so? Okay.
Next.
Are you
Also, you should be
also
running up. I have another matter.
yes, my lord. Are you also aware that based on your petition, the defendants were arrested and had to secure their bail?
I was aware that the IPO, I think the police sent an invitation to parties to come to the police station
Okay.
during the
So you
course
are
of the
not aware they were
investigation.
arrested?
Honestly, I don't know. I don't know if anything
And so you are
happened.
not, it's fine. You're
Yes,
not aware.
That's the
Yeah.
question.
And you're also not aware that they
Sorry,
had to secure their bail.
can you
My
just
lord,
give me like a
my
timeline?
lord, the witness has answered your question that
Being
he's
an
only
arrest.
aware that he's only aware of police invitation. If there is an arrest or bail, the witness is not aware of that. She has explained. She only aware of invitation. Whether there is a bail or not, she's not there. There's no way she can know.
My
Counsel,
lord,
if my lord, if I may clarify based on his question.
Yes, go ahead quickly.
Please, I would like to confirm if you're talking about an arrest recently or an arrest from when we filed the
I'm
petition.
coming to the arrest recently. Hold on. I'm talking about
Okay.
the one in zone 2 last year. There are two different things. We'll come to that one.
Okay.
Yes, you submitted a petition against the defendant. You said
Yes.
yes. I
Yes.
asked you for the offenses. You said you cannot recall. And I asked you, are you aware that based on your petition, they were
I said on
arrested? You said, "I'm
criminal
not
nature.
aware."
Yes, please.
Yes, and I asked you, are you aware that they had to secure their bail? And your learned counsel tried to answer for you. You've not answered the question. Are you
No, he
aware
did.
they secured their bail? Is it yes or no? I'm
I
not
said
aware.
no.
No, that's it. I'm
I said
okay.
no.
Why your counsel is trying to answer for you?
Please,
Which
counsel,
is why
let's keep ourselves in respect here. Please, please. Don't
You've answered
repeat
my
that.
you've answered my question, witness. Okay.
Go ahead then. Go ahead with the question. You're
Are you
running up
also,
in the next 5 minutes.
as court please,
As a
are you
court-
also aware that after after many invitations by the police, the first defendant was arrested again in Abuja last year in a bank? Are you aware?
no, I was
By
not
the
aware.
Nigerian police. Sorry?
No, I was not aware.
You are
No,
not aware.
I was not aware. No.
I'm not aware of any of the.
Go ahead. Go ahead. Go ahead.
Yes. Are you aware again that based on another petition by you or your company, the first defendant again was arrested May this year in Port Harcourt?
Come again.
Are you also aware that based on a petition by you or your company, the first defendant was arrested again May this year, 2026, in Port Harcourt?
I was aware that there was an invitation that was made to parties.
In May?
Yes, invitation.
In May. Okay,
Yes.
but you're not aware of the arrest, that they were arrested, that the first defendant was arrested?
I don't work with the police. Like I said, I was aware of an invitation. I was aware that parties were invited by the
Were
police.
invited as the
By the
court please.
police.
That will be all from the defense, my lord.
Okay. So re-examination quickly.
My lord, there is no re-examination. None of us are not to waste the honorable court's time. However, my lord, we have filed an application for subpoena. So in view of that, my lord, we'll be asking for another date.
Okay.
That's our humble prayer as the court prayer.
Okay. Khadijat, registrar, are you still on?
Yes, my lord.
Okay, give us a date quickly.
My lord, 22nd July.
Okay. Is that a convenient counsel?
But my lord, I'm trying to check if that it is convenient. Okay, 22nd July. It's convenient, my lord. And
Okay.
also, my lord, may I also ask that the witness be discharged from the
Okay,
virtual
yes.
witness box? And second one.
Okay, CW1, you're discharged from the box.
As a court
Most grateful,
process.
my lord.
Okay. Have we agreed on the date?
Yes, my lord. 22nd July.
Okay. So case adjourned to 2 July 2026 for continuation of trial.
As the court pleases.
So you can all leave the meeting now. Counsel and parties for this matter, leave the meeting. Registrar, call the next case.
Yes, my lord. NICN/LA/15/2024 between Isaac Tony Ogidi and one Silsado Contracting Nigeria Limited, two Bridgeside Nigeria Limited.
Parties and the parties announce their appearance.
No, my lord.
None is in court. Okay. Counsel, who is in
They are
court?
online. They are online, my lord.
Oh, they are online. Okay.
Yes, my lord.
So who is in court? Is the claimant in court?
No, my lord.
Okay. The defendant, who is in court?
They are online before my lord asked them to leave the
Okay,
Zoom
they all
meeting.
left the meeting. Okay. Can you
Yes.
call them? Call them. Tell them to join.
Yes, my lord.
Okay.
Good. Can I talk like this?
Nobody has nothing. Wow. Nobody has entered. Only nobody is there already.
So I'm there already.
And
I have to see how to go. Okay.
we've not started.
Some good here.
Ajia. Wọ́n láwọn fẹ́ fáìlì pẹ̀lú.
Registrar. Registrar.
Yes, my lord.
Okay. Call the case quickly.
Yes, my lord. NICN/LA/15/2024 between Isaac Tony Ogidi and 1 Silsado Contracting Nigeria Limited, 2 Bridgeside Nigeria Limited.
Who is in court?
Your Lordship, I'm here. Isaac Tony Gida, I'm in court. The
That's the
complainant.
claimant.
I'm in court.
Claimant is in court.
Yes.
Okay.
Yes, my lord.
Okay.
Appearance.
Appearances, yes.
Yeah, Sir Loje Aniago for the complainant. LOJE
Claimant.
Aniago, complainant.
It's not
Yeah, for the
complainant, it's
claimant.
for the
Sorry,
claimant,
for the
yes.
claimant. Sorry, my lord.
Okay. Okay.
Claimant. Yes.
Okay. Who again is in court?
May you please, my lord?
Yes.
I.O. Abdulhamid. Abdulhamid is spelled ABDULHAMED, my lord. I appear for the first defendant.
Okay. Yes. Is the second defendant represented?
He was here initially when the court was about to sit. Maybe I should contact him and tell him that we are not back.
Go ahead quickly.
Thank you, my lord.
My lord. My lord.
He's now online, my lord.
No. Okay. Okay.
Is second defendant counsel in court now?
Yes,
my
my
lord.
lord.
Yes. Hello.
Doctor, the court is waiting for you.
Second defendant counsel. Is he in court? Is he online?
He's online. I saw him now. Saw his video now.
Registrar, can you call? I can see him now, Dr. Jerome Okoro. Second defendant counsel.
My lord,
Yes.
I'm deeply sorry. I was coming in at intervals during the previous proceedings because my lord
Okay.
instructed that we should leave at a
Okay.
point. Yes, my lord.
Okay. So announce your appearance so we can go on. Announce your appearance so that we can go on. What is going on? Hello? Sanyogo, can you hear me?
I am hearing your lordship very well.
Mr. Abdullah Hid, can you hear me?
Yes, my lord.
Dr. Okoro, can you hear me? Hello?
Doctor, what happened? Okay, maybe network.
Registrar. Registrar.
Yes, my lord. Yes, my lord.
Can you call Dr. Okoro to join the meeting through another device? Did you get that?
Yes, my lord. The second.
Yes, ask him to join with another device.
Yes, my lord.
We are all waiting for him. We can see him,
Yes,
but we
my
can't
lord.
hear from him.
My lord,
Yes,
my
Registrar, I
lord,
can hear you.
I'm calling the council. He's not picking.
Send him a text message.
Yes, my lord.
Tell him to join the meeting using another device. There's something wrong. There's a network problem with the one he joined with.
Yes, my lord.
We can see him, but we can't hear what he's saying. Get back to the court quickly. Dr. Koro?
My sincere apologies, please. I was
Okay.
I was dealing with a network instability here, but I think it's resolved now.
Okay, good.
Yes,
Okay.
I've got external source connection. I most sincerely apologize to my lord. I'm sorry, your lordship.
No problem. Go ahead. Go ahead. Announce your appearance.
With profound respect to this honorable court, I am Dr. Jerome Okoro. I most humbly appear for the second defendant.
Okay, good.
Thank you, my lord.
All right. So where are we on this matter? Mr. Abdulhamid.
Abdulhamid, my lord.
Yes.
Yes, my lord. We are to start our evidence. Our witness is before the court, my lord.
Okay.
The fourth defendant, my lord.
Okay.
To open it.
Yes.
Of defense.
What's your
Mr.
witness name? Is it Lawal?
Lawal, Oseni Lawal, yes, my lord.
Okay. Tell him to turn on his video so that the registrar can administer the oath.
Mr. Lawal, turn your video. Turn on your video. Mr. Lawal, are you not with us? Let me get in touch with him.
Yes, he's on. Yes, I can see him now. Khadijat.
Yes, my lord.
Okay, administer the oath quickly. He's online now.
Where's my lord?
Yes, my lord.
Tell him to turn on his loudspeaker.
Good afternoon.
Okay.
Good afternoon, Mr. Lawal.
Good afternoon to you. Good afternoon, everyone on the call.
Are you a Christian or a Muslim?
I'm a Muslim.
Do you wish to affirm or sworn by the Holy Quran?
Affirmative.
You repeat after me.
I,
followed by your name, sir. Your names.
I, Oseni Lawal,
Affirm that the evidence I shall give in this case.
affirm that the evidence that, please come back.
I,
Oseni Lawal,
affirm that the evidence I shall give in this case.
The evidence that I shall give in this case.
The evidence I shall give in this case.
The evidence that I shall give in this case.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
My lord, the witness has affirmed.
Okay, good.
Yes, fine.
Mr. Tunji, go ahead.
Yes, my lord. Mr. Hussein, please tell the court for the record again, your name, address, and occupation.
All right, my name is Hussein Lawa. I am a resident of number 1 Asidi Close off Igbo Road of the DSC Expressway, Warri Delta States, Nigeria. And I'm the Earth Safety and Environment Manager. Thank you.
All right. Can you please confirm that on the 5th day of April 2024, you depose to a statement of oath?
Yes, I can confirm.
Please take a look at this evidence on oath. I don't know if you can see it.
Please, can you just take it closer to your camera?
I'm doing that.
What year again? Mr. Tunji, what year is that?
It was 5th April, 5th day of April 2024.
Yes, I can confirm.
All right. What do you want to do with this statement?
Just to submit it to the court as my evidence.
Again, in paragraph 5 and 6 of the said statement, you made reference to a letter dated 29 July 2023. Is that correct?
Affirmative.
My lord, may I seek for exhibit C7, my lord?
Hold on, Mr. Lawal. It is either yes, my lord. There's nothing like affirmative in court. Do you understand?
Right. Okay, noted. Yes, my lord.
So the last question, Mr. Tunji, was you referred him to paragraph 3, right?
Paragraph 5 and 6, my lord.
Okay, 5 and 6.
Yes. You made reference to a letter dated 29 July 2023.
Yes, my lord.
My lord, can I proceed?
Yes, go ahead.
My lord, the said letter has been admitted as C7. I want to show it to the witness to confirm it that is the letter is referring to.
Okay.
Exhibit C7, my lord. May I apply for it?
Kadijat, do you have
Yes,
the exhibit
my
file?
lord. Yes, my lord.
Okay.
My lord, the exhibit C7.
Yes.
State contract of employment as community relations coordinator.
What do you call it now? Is that the letter you referred to in paragraph 5 and 6?
Yes, my
Mr.
lord.
Lawal.
Yes, my lord.
My lord, the witness have found that that is letter. My lord, in view of the fact that it has been admitted, I will not retender it. We will rely on it.
Okay then.
My lord, that will be all for the witness.
Okay.
That will be all for
cross-examination then. Mr. Anyogo, sir, Anyogo, please turn on your microphone.
Can I go on?
Yes, go on. We can hear you now.
I can. Okay. Mr. Lawal, You, as a safety manager or former safety manager, I presume that you were safety manager as at the time the event leading to this action took place. Am I right?
Yes, my lord.
You were the safety manager. Thank you.
Health, safety, and environment manager.
Okay. Am I also right to say that you witnessed exactly what happened in the bush at that particular, on the, was it 6th of, sorry, on that particular date, because I don't have the date immediately. You were you with the, were you in the field when the event leading to this case took place? Were you at the scene?
Please, I would want you to really be specific with the scene.
The scene, the event that took place, which gave rise to this action. Okay, that's the termination of appointment of this claimant. You didn't get me?
Mr. Lawal, go ahead, answer the question.
I needed to be sure of the question. The question should be specific because he mentioned that he is not aware of the scene or he is not with something.
Hold on. Listen to what I have recorded. Am I right to say you were witness to what happened at the site/field when the events leading to this case took place? That is the termination of appointment of the claimant.
Okay. Yes.
He said yes. Go ahead.
Okay, you were at the field. Did you also witness the physical manhandling of the claimant in the field that same day?
No.
My lord, I'm sorry. The questions are vague and general. There's no specific date and the specific issue being addressed. He's just generalizing it. And that would
we are not generalizing. Sorry, we are not generalizing. He knows the event that took place. Specifically, to mention date, I think it was the 6th of October. Okay? So the issue is it happened in the field. It happened in the field. And the site now.
The termination was not at site, sir. You asked question if I know about the scene. The termination was not at site.
Okay. Where was the termination?
It was from the process of employing and at the same time disengaging. It's not at the site, it's in the office.
Hold on. So the question is, where did the termination take place? Is that the question, Sir Anyogo?
Yes. I was trying to, sorry, my lord. Whether he was there at the site when the termination took place, 1. 2, whether he witnessed the physical manhandling of the claimant at the site during the course of the purported termination in the field.
Like I said, termination is not at the field because the field is the work zone, right of way where we do our job.
Just take it easy, I'm writing. Hold on. Witness, take it easy, I'm writing. You said the termination was not at the site?
It was not at the site.
Okay. Where was it?
It was just like when you are looking for employment, you go to the office.
No, tell me the site quickly. Witness, we don't have time for long stories. Go straight to the point. The question is, Where did the termination take place? And you said the termination was not at the site. So where did the termination take place? You brought up the issue of site. Where did the termination take place?
That question for me.
Business.
Can you hear me?
Hello?
Mr. Lawal, they are waiting for you, Mr. Lawal, to answer.
Okay, it was in the office now. In the office, project office. We have project office.
Hold on. So your testimony is that the termination was not at the site, it was at the project office. Is that your testimony?
Yes.
Thank you. Now, did you know, or could you recall exactly? Oh, sorry, my lord.
Go ahead.
I'll put something to you. On that particular day, I'm putting something to you.
Okay.
And that is that on that particular date, the termination took place at the site, was forcibly being bundled into the van, into your vehicle, Hilux, Toyota Hilux Jeep, with Alessandro ordering that your job is hereby terminated. Go. They wanted to bundle him into the vehicle, and he was resisting. You are aware of this?
I'm not aware of that, sir.
Thank you. Thank you. Thank you. Secondly, are you aware that the claimant's computer instrument of work was immediately snatched from him as he was being asked to leave? That he is no longer in the employ of Sisi Saudo. Were you aware?
I'm not aware because it's on the right of way where we work. There is no office for computer.
Okay.
Get that. Hold on, let me get that. So you said it. I'm not aware because it was at the site, which is the place of operation. Is that your testimony?
Yes.
Okay, good. Next question then.
Okay. Were you aware, or are you aware of any recall of the claimant after the termination? Was he ever recalled?
Come back with your message. Let me get it clear.
After the termination of employment of the claimant, Satuni Ogidi, was he ever recalled by Sisi Saudo?
None that I'm aware of.
You say?
None that I am aware of.
You were not aware of any recall. Thank
None.
you. Okay. Okay. Thank you. Thank you. Thank you. I think I'm okay with the witness. I'm okay with him.
Okay, good.
I'm okay with him. The last answer summarizes everything. I'm okay with him.
Okay.
So that's all.
Okay. Mr. Okoro, Dr. Okoro. I can't hear you. Your mic.
I'm sorry, my lord.
Okay.
I hope I can be heard by my Lord now.
Yes, I can hear
I'm
you now.
unmuted, yes.
Okay.
Okay. Mr. Lawal.
Good afternoon, sir.
Blessed afternoon, Mr. Lawal. Mr. Lawal, the suspension of an employee is the duty of an employer, is the right and duty of an employer. Suspension of an employee from work. Is that the duty of an employer to suspend employee from work?
Yes.
Okay, now let me take you to your, my lord, the answer yes. Let me take you to paragraph 8 of your witness statement, which you just adopted. Paragraph 8. Are you with the statement there?
Hold on, let me try to get, yes.
Okay. Please look at, read to my lord the first two lines of paragraph 8.
The letters written by the first defendant to the claimant were to allow proper investigation by the team set up to investigate the roles of the claimant in the petition written by the conference. Okay,
It's okay.
you said it.
Okay. It's okay. So these letters that you mentioned that the first defendant wrote to the claimant, does it include a letter of suspension? Does it include the letter of suspension admitted as Exhibit C1?
Let me check.
As a letter of suspension.
When you refer to Exhibit Z1, please, can you please specify?
Okay, I apply my lord for the registrar to bring up Exhibit C1.
Registrar.
Yes, my lord.
You have the exhibit file then?
Yes, my lord.
Okay. Get exhibit C1 out.
Yes, my lord. Exhibit C1 states suspension notice.
So you confirm that the first defendant issued.
I'm sorry, my lord. In view of the fact that the witness may not be aware of the said letter, I think it's right for him for them to read the entire letter to him so that he will know exactly what he's answering to. The heading may not be enough because he's not aware. I'm not sure he has read that. He has gone through that letter as it is now. As today.
No objection to that.
Dr. Okoro, I don't have the time to read through that letter. Can you refer the court and the registrar to the particular? I think there are 3 paragraphs I can see on that letter. Can you refer the registrar to read the particular paragraph you want to bring to the attention of the witness?
Okay, the first and the last paragraphs.
Okay, registrar, go ahead and read it out.
Exhibit C1, suspension notice. Equal to the petition received from the Conference of Host Community of AKK Project Charlie, spread dated 4th October 2023. I am writing to inform you that after careful consideration and investigation, the company has decided to suspend your employment with immediate effect. This decision has been made in accordance with our company's policies and procedures. Then the paragraph 4. This suspension is not
I think that's enough. That captures that's enough.
I think that paragraph is important so that the witness will not become.
Fine. Go ahead and read. I'm
Read
only
paragraph 4
considering the
quickly.
time.
Read paragraph
this
4
considering
quickly.
the time.
this suspension is not a final determination of your employment status. The purpose of this suspension is to provide an opportunity for comprehensive investigation into the matter, and a decision regarding your employment will be made based on the findings of the investigation.
Okay. Mr. Lawal, the suspension notice proceeded from the first defendant to the claimant. Did this suspension notice, was it issued by the first defendant to the claimant?
I'm trying to look at that because it's not too clear for me. If I can see who sent that to who sent it.
Registrar, read out the name of the person who signed the suspension notice.
Giovanni Asia Silsado MD signed it, addressed to Isaac Tony.
Please, can you tell me the dates? The dates?
But
Dated.
it's on the body of the first paragraph that there's a date, 4th October 2023.
It's undated, registrar. It's not dated.
Yes, there's no any date.
Okay. So the question, did this suspension notice issue from the first defendant to the claimant? And what is your answer? Quickly, so we can move on.
I cannot really give an answer because it's not clear. Maybe if I can get the whole of the document for my review.
Okay. In paragraph 8, you read paragraph 8 of your statement. You read paragraph 8 of your statement, and in paragraph 8, you refer to letters written by first defendant to the claimant. So I ask you, the letters you're talking about, do they include suspension notice signed by Cecil Saldo and issued on the claimant?
Well, I may not really be able to answer this question because it's generic for me.
Witness. It is your witness. It is your witness statement on oath that counsel is referring to. You should have that before you.
Yeah, but the letter, I don't have that particular letter that is referring to right now.
Okay, so when you said in your witness statement on oath paragraph 8 that there were letters you wrote.
It's not that I wrote. I did not write letter.
Okay. So which letters were you referring to quickly? Which letters were you referring to? Please, we don't have much time.
The letter they wrote from the petition or something from the community.
So those are the letters you refer to in paragraph 8?
Yes.
Okay.
Witness, you specifically mentioned letters written by first defendant, which is Cecil Saldo, to claimant.
Mm-hmm.
In paragraph 8, I ask you, do these letters include suspension notice? You mentioned the letters because you are aware that Cecil Saldo wrote letters to Mr. Isaac Ogidi. Do the letters include suspension notice?
Sorry, I'm trying to check.
Paragraph 8 is before you. What are the letters?
Okay, do you have your witness statement on oath before you witness?
trying to.
That is your testimony before this court, so it should be before you. If you don't have an answer to that question, please let the court know so we move forward.
As court pleases.
That particular clause is on the because if you go down towards the last two paragraphs, the project against the first defendant manager following an allegation that the said petition was instigated or masterminded by the claimants. So it's actually based on the petition.
I'm not asking about the basis. I'm asking if suspension notice is part of the letters written by Cecil Saldo. Did Cecil
I may
Saldo
not be in a
write?
better position
as mentioned in
know if
paragraph
that
8.
letter, I may not be in a better position to mention if that letter is a suspension notice, unless I get the exact date it was sent.
Okay. I'll move on to the next. Mr. Lawal. Mr. Lawal.
Yes, sir.
Okay. One of the duties of the employer is pension contribution to the employee, remittance of personal income tax, and National Housing Fund. Is that correct? Pension contribution and remittance of National Housing Fund. Is that one of the duties of employers or employee?
Are you referring to? Are you referring?
Hold on, witness. Hold on. Just Dr. Jerome, you refer to 3 obligations: pension remittance, NHF remittance, and what again?
And payee, personal income tax remittance of employee. Is that duty of employer?
As mentioned in our contract, yes.
Okay. Please take a look at Exhibit C7. Exhibit C7 relied on by the first defendant. That is the contract of employment. Contract of employment. Exhibit
Yes, what is the question?
Okay, precisely clause 9. Clause 9 of that Exhibit C7.
Please, can you read it?
Okay, registrar, please bring up Exhibit C7.
Registrar, do you have Exhibit C7 before you?
Yes, my lord.
Counsel, refer here to the paragraph in Exhibit C7.
Item 9, that is clause 9. They are numbered. Item 9.
What page of the document?
The first page of the document. Page 1. Item number 9. They are numbered.
Okay, statutory. You are legible.
My lord, I'm sorry, my lord. It's also important to state that who wrote that letter, because it's ambiguous now. The letter is talking about, he doesn't even know which letter they are talking about now. He's not seeing them, even though he referred to them.
My
So
lord, the letter is referred to and relied on in paragraph 5. Paragraph 5 of the witness statement on oath of Mr. Lawal Oseni, which he adopted. The exhibit C7 is also relied on, adopted and relied on by counsel in examination in chief. The exhibit is referred to in paragraph 5 of the witness statement on oath of the witness.
Okay.
That's why I want to refer him to ask him a question on clause 9 of that exhibit.
Yeah, my lord, I'm not saying he's not asked that question. If the claimant were to be in court, the letter will be shown to him. He will see all the details. Now you are hiding details of who wrote the letter. That's the point I'm making.
With registrar.
Yes, my lord.
Can you lift that document up to your camera? At least let
Yes,
him
my
see the
lord.
letterhead and then who signed the letter. Take it closer to your camera. I can see it. Take it closer. No, you're missing the camera now. You have missed the camera.
Up.
Take it up again. Yes. Go to the bottom of the letter. Go to the bottom of the letter.
My lord, is a 2-page document.
It's a 2-page document. Okay, go to the second page. Are you there? Okay.
Yes.
Try and focus on the camera. You are missing the camera. Try and focus.
Now, I think it will be more easier to just state that the letter was written by social person, addressed to social person, and signed by social person. It will get
Registrar.
it.
Okay, registrar. Who
Yes,
signed
my
that
lord.
letter?
On the first page of the document is Bridge Site Nigeria Limited, dated 29th July 2023. To Mr. Tony.
Law school student, sit up. I can see all of you from here. Law school student, sit up and listen to the proceeding.
Okay, ma'am.
Okay, go ahead.
My lord, it was signed by Doris Paul John. Paul John is a compound name.
Okay.
HR/admin manager. Dated 13th August 2023.
No, it's not dated 13th. It was received on 13th August by Tony, not dated.
Yes, by Tony. It was received on 13th by Tony, but was signed by Doris Paul John, HR/admin manager.
Okay. So witness, you referred to that letter in paragraph 5 of your witness statement on oath.
Yes, just one information I will need. What is the number? Is it the one that has our ref BNL/AKK/07/028?
Yes.
Okay, yes.
Okay, so Dr. Jerome, go ahead with the question then. He has identified the exhibit.
Okay. I'm referring him to clause 9. That is to item 9 in that letter. To clause 9 in that letter. Clause 9 of that letter.
So what is the question on clause 9?
Let him read clause 9. Or let clause 9 be read out to him.
Registrar, read clause 9 quickly.
You are eligible to pensions contribution of 8% employee and 10% employer contributions monthly. Group life insurance, NISTF, ITF, and payee shall be obligation of the client.
Who is the client here? Is it correct to say that the first defendant, Cecil Saldo, is the client referred to in that letter, in that clause? Is it correct to say that Cecil Saldo, the first defendant, is the client mentioned in that clause 9? Is it correct?
Well, from what I can sense, if I should answer that question, depends on who is paying the salary, because we don't get salary from Sisisado. Bridgeside pays us, so I will say Bridgeside.
No, witness. The clause 9, the wording of clause 9 is explicit. It has been read out and a client is mentioned there. What I'm asking you is, Is Cecil Saldo the client referred to in that contract document, clause 9 of that document? Is this Cecil Saldo the first defendant?
Witness, if it is not, let us know quickly so we can move on. Witness, can you hear us?
Yes, I can hear you.
My Lord, I'm sorry for interjecting. My Lord, and that's why I was saying, except he go through the letters, because these are documents that speak for themselves. It speaks for itself. So it's not for witness to interpret it again.
The letter is attached to his witness statement, which means he's aware of it. Which means he's aware of it. Who is client? And client is not ambiguous. It is not. It's not subjective. Who is the client referred to in clause 9 of that letter? Who contributes pension and remits personal income tax? Who is that client? Who is that client? I've given you a lead by saying it is Cecil Saldo. Is that not so?
That's a leading question, my Lord. That's a
leading question is allowed in cross-examination.
No.
Mr. Witness, if you don't have an answer, can we move on, please?
I cannot really answer that question because
okay, good. Okay, go ahead with the next question.
Are you aware that the claimant had employment interviews or had an employment interview with the first defendant before he assumed the duties? Before assumption of duties, before the commencement of his employment, are you aware that the claimant had employment interview with the first defendant?
I'm not there. I don't know if there was any.
Is it correct to say? Is it correct? Is it correct to say? Is it correct to say? I'm sure my Lord noted the answer.
He said I was not there. I do not know.
Is it correct to say? Is it correct to say that is it correct to say that you are not the HR human resource manager of Cecil Saldo, and for that you are not involved in the recruitment process? It's from your last question. Is it correct to say that why you are not fully involved in the recruitment process of the first defendant is because you are not the human resource manager?
Can you come back and, please just rephrase your question again, please?
You said you were not there. You said you were not there. And I said, is it correct to say that as you are not the human resource manager of the first defendant, you are not fully aware of their recruitment process? In other words, why you are not fully aware of the recruitment process of the first defendant because you are not in charge of human resource affairs. Is that correct? Is it a correct statement?
Thanks.
Remember,
yes,
you said you were not there.
Yes, it's a correct statement.
Okay.
My Lord, the witness has answered.
Yes, it's a correct statement. I confirm that he is not the HR of Cecil Saldo and was not involved in the recruitment process.
Who is Kanata Ignazio? Who is Kanata Ignazio in the first defendant? Who is Kanata Ignazio? Are you aware of a name known as Kanata Ignazio?
Maybe you are not pronouncing it well, please.
Kanata is spelled the way I pronounce it. Kanata-Ignazio. Kanata Ignazio. Who is that person? Is there anybody like that? Or was there anybody like that in the first defendant's organization, Kanata Ignazio.
Yes.
Witness, did you get the question?
Please come back again with the question.
I'm asking you, do you know of a name, Kanata Ignazio, in the organization, in the structure of the first defendant? Are you aware of the name Kanata Ignazio?
Yes, I am aware.
Who is he? Who is he? What's his position?
1 minute, please. He works in the HRO department.
Okay.
It's actually his signature on his email is Ignazio Kanata, HRO and administration. That is what is there.
Thank you very much. Now, last question. Last question, if you make it the last. Are you aware that the first defendant signed a contract document with the claimant in respect of the employment? A document on contract of employment with the claimant before his employment. Are you aware of that?
Come back. You said a contract of what?
An employment contract. Are you aware of an employment contract? Okay, fine, let me rephrase. Did the first defendant sign an employment contract with the claimant before the claimant's employment?
None that I'm aware of.
Please take a look at this document. Take a look at this document. Is it clear on the screen?
Not clear.
Was it front-loaded?
My Lord,
Dr. Joyce?
Yes, it's front-loaded from the second defendant's processes, but it's relevant in this cross-examination. That is the letter of intent AKK project, jointly signed by Sisado Contracting Nigeria Limited and worker Isaac Tony Ogidi on the 15th of July, 2023.
Please, who signed this letter for us?
I'm sorry, I've not seen the paper is right on the paragraph where it was
Just look at the signature first. That is where we are. Counsel and witness, look at the signature. It's on the screen of Dr. Okoro.
Sorry, please, I don't know if I can get like a scanned copy of this particular evidence.
You cannot.
No, you cannot get that now. Your counsel can send it to you later.
It is served on.
No, even me as counsel, I have not seen the letters from what was filed.
No,
he said it was front-loaded.
And served on additional witness, additional documents is additional document among the additional documents of the second defendant.
Additional documents?
Yes, dated, just a minute, please. We filed a list of additional documents dated the 27th of January 2025, and it served on all parties. You see amended list of witnesses of the second defendant. It's filed alongside with additional list of documents of second defendant. And then there are two documents there. This is one of them. It's served. It's in court record.
I can see your motion to rely on the additional documents, but I've not seen the documents.
No. Amended list of witnesses, second defendant. That is dated 27 January 2025. In any event, what is most relevant now is whether Sisal signed, and the document says so.
No. We have to ascertain whether or not it's relevant or it's pleaded. We have to identify that first.
It's pleaded. I've referred you to where it's pleaded.
Is it a contract document? Let me be sure of it.
It is. It has not been tendered. So I won't ask registrar to. It is signed by Cecil Saldo and the claimant on the 15th of July 2023.
And if my lord have seen it, I have not seen it, my lord. If before my lord, I will have no choice. I'll go ahead.
It is in the court file.
Okay.
So go ahead with the question quickly. Let's round up.
So the question that I asked is whether Cecil Saldo signed a contract document, a document on contract of employment with the claimant before his employment.
Witness, we are waiting for you.
No. The only contract I have is the one I signed with Bruce Sites. That's the contract document I have.
Now I have shown you this. I've shown you this document, which is signed by the second defendant, by the first defendant, sorry, with the claimant. Take a look at it. This is the first.
What is the title of this document? Sorry, please.
The title of this document is what you are seeing here.
Please, can you read it out?
I can't see it.
Please help me to read it out, please.
Letter of intent, AKK project. Letter of intent, AKK project.
That's not, for me, that's not the contract document that we usually sign. What we sign is we sign is the contract document by our employing company, which is Bridge Sites.
Okay. Was this document signed by, who signed this document? From what you are seeing it. Who signed the document?
The particular person you refer to, when I checked, is not even available again. He is left. So I don't really know if he's the one that signed this or not.
But it's signed. It's signed in the name of the first defendant.
That is what I'm saying. The contract documents that I am aware of, that I have a copy of, is the one that is issued to me by Bridge Sites.
What is the date? What's the date? What's the date of the signature that you are seeing there? What is the date of signing that you are seeing on the screen?
It's not too clear.
The date there, which is very clear, the date there is 15/07/2023. Can you see it? 15/07/2023. Can you see it now? 15.
Well, like I said before, I don't know if, I don't have any idea about this. None.
Okay. Mr. Kanata Ignacio, who signed this document, was the HR manager of the first defendant as at 15th July 2023. Is that correct? Mr. Kanata Ignacio, who signed this document, was the HR manager of the first defendant as at 15th of July 2023. Is that correct?
Like I said, the signature I have with the email communication is HRO and administration. I don't know whether it's the HRO manager.
Okay, HR. There is Kanata Ignacio in the organization of
Ignacio Kanata, HRO and administration.
Okay, fine. But there is Ignacio Kanata with the first defendant. Is that correct?
He has confirmed that second defendant counsel. You had asked him who Kanata Ignacio was, and he identified Kanata Ignacio.
Okay, as I identify Kanata Ignacio, my lord, I seek to tender this document. I seek to tender the document.
Okay. Unfortunately, I have not seen the copy of the document from my side. I don't even know whether we were served with it or not. But anyway, my lord, I will not be objecting to it. I will not be objecting to it. The documents speak for themselves, and he has said it. So I will not object to it.
Okay. Idiot. Registrar.
Yes, my lord.
Dr. Jerome, can you read out the title of that document?
The title is at the top head is Saldo Contracting Limited, and it's titled Letter of Intent, AKK Project. Letter of Intent, AKK Project. That's the title of the document, and it was filed. It was filed on the. It was filed on the 27th.
Filed on what date?
On the 27th of January. Is dated 27 January 2025. Filed on the same date. Sorry, it dated 27 January. That's the second. I'm sorry, my lord. Second defendant's list of additional documents is dated 27 January 2025. But it was filed in court on the 28th of January 2025, my lord. For accurate record, the filing was on the 28th of January 2025.
Okay, so this letter titled Intent, Letter of Intent, AKK Project. This letter of intent, hold on. This letter of intent, AKK Project, is admitted and marked as Exhibit 2nd D 1 in bracket. Exhibit 2nd D 1 in bracket.
My lord, I'm sorry for interjecting. Dr. Jerome is confusing me. I'm not, because the only witness he has and the statement of oath of a witness that he filed that before the court now is dated 20th March 2024, and in that list of documents there's nothing like that in it.
I filed that, my lord.
There's no list of documents for 2023 that filed by Dr. Jerome in 2020 that he filed a new one, which is what was filed on 20th March 2024.
Please, I filed the first memorandum of appearance, and then witness second defendant's defense, front-loaded with witness statement on oath and list of documents. That witness is supposed to be Kile Nankwat, Mr. Kile Nankwat. Later, I moved a motion before this honorable court to substitute the witness, Mr. Kile Nankwat, with Mrs. Ogechi Emeziem, And in that same motion, I prayed for an order to bring in additional documents. And that motion was granted. And then I later moved the motion for virtual hearing. And after granting of that motion, I now filed amended list of witnesses and also filed the second defendant's witness statement on oath coming from Ogechi MSDM this time. Additional second defendant's list of additional documents, wherein there are 2 documents. And one of those 2 documents is the document just admitted. This was filed on the 28th of January 2025 and served on all the parties. Perhaps there was a mix-up in the record of the first defendant's counsel. And the court's record can bear me witness on this, my lord.
I will address it appropriately at the final address.
Yes. In any event, to contradict a witness or cross-examine a witness with a document made by that witness does not depend on whether that document is already before the court. But in this case, we are saying it's before the court. A witness can be confronted by the evidence at my lord. The witness can be, I'm referring to section 232 precisely of the Evidence Act. A witness can be confronted with a previous statement made in writing. Section 232. Section 232.
I don't want to argue that with him. Made in writing.
Yeah.
The witness did not sign this letter you are talking about.
The witness.
He wasn't the one. They are not the same thing.
My lord. Yes, my lord.
You can address these issues at final written address stage.
My lord, that is my last question. But for the sake of the law students, section 232 of the Evidence Act permits confrontation of a witness by previous statement made by that witness. And the witness we are talking about here is the first defendant, Cecil Saldo. Is not necessarily Mr. Lawal Oseni, my lord. Mr. Lawal Oseni is actually the first defendant we are seeing. He is an employee of the first defendant. He is the representative of the first defendant that we are seeing now in court. The first defendant is a juristic person. He can never sign anything in his own name. So whoever signs that is an officer of the second defendant, it binds any other officer of the first defendant. That is elementary company law. By virtue of incorporation, whatever an officer of a company signs is binding on that company and on every other officer of that company in official capacity.
I don't want to argue with Doctor. He did not. He wasn't the one who signed that document.
Mr. Tunji, that information is for the benefit of the law school students, not for you.
My lord, the law student may be misled. That's why I'm trying to also contradict that. It may be misled. It's not general.
We will look at that in chambers.
Yes, my lord. Besides, one of the principles of amendment, in case a document comes in during cross-examination and is not pleaded, there's a principle of amendment that allows for amendment for the purpose of bringing pleadings in line with evidence that has been adduced during the trial that was not previously pleaded.
That is done.
But in this case, I've relied on section 232 of the Evidence Act, and the witness is the first defendant we are seeing, sections 42 and 43 of the Companies and Allied Matters Act 2020. The company does not, Sisado will not walk into the witness box. Yes, my lord. That's the last question. That's my last question, my lord.
That's the last question.
My last question, my lord. Yes, I'm done with the witness. Thank you, my lord.
Okay. So re-examination. Sorry, Sir Anyogo. On your mic.
Yeah, I'm muted.
Sir Anyogo? No, we can't hear you. We still cannot hear you. Okay.
The document in question, my lord, was actually exhibited at before the court during our previous sessions. We were served. I confirmed that we were served. I saw the document. That was what I was just trying to indicate to the court. We were served. We were duly. Thank you.
Okay. Okay.
Thank you, Mr. Nyago. Thank you.
All right.
Yeah, well, it will show me every end of service to a nurse.
Is there any
doctor.
re-examination?
Yes, my lord. Just one. In the course of answering question, put is the witness said something, and I need clarification on that to the court because it's ambiguous. You said what you signed was a contract with your employer. With your employer? Can you tell the court who your employer is?
Hold on.
No,
You said what you signed. You were asking contract signed by.
Objection, my lord. Objection. I object to that question, please.
Yes,
no,
I'm noting that.
He said, my lord, he said initially that that was engaged by Bristol. So and you see now we are talking about Cicidado as well. So which of them is talking about? That is the ambiguity, my lord.
No, my lord. I can't even recall that answer or whether it was written down. I can't recall that answer and whether that answer was recorded in by my lord. And then if recorded, there's no ambiguity there.
No, there is. He mentioned two names of two companies.
His employer. You say his employer. His employer is not in question here. It's the employer of the claimant that we are talking about.
No. There's an ambiguity in his question. He said the letter he saw was signed by Bristol, who is their employer.
Which letter, Mr. Tunji? Which letter is that?
No, he was Mr. Doctor that asked him about a contract. I think this letter of intent we are talking about. I'm not even this particular letter of intent that I said that I don't have. And he said the only one he's aware of was one signed by was one by his employer.
Okay, hold on. I have a quick. I can see a question here. You said who is Kanata Ignacio? He said in the first defendant. He said yes. Is Kanata? Who is he and what is his position? He said he works in HR department. Then the next question: are you aware that the first defendant signed the employment contract document with the claimant before his employment? He said none that I am aware of. Then this letter is the joint letter signed on the 23rd of July 2023. It is the additional documents of the second defendant. So that is the question, and those are the answers. So I don't know where your question is coming from, Mr. Tunji.
Please.
Well, maybe my lord did not capture when he was saying it. He said it, and I heard it.
Okay,
when he was asking regarding clarity on the letter, because my lord, he took time to understand the letter they are talking about.
He was trying to identify the letter and who Kanata was. So I don't think that question arises.
As call places.
He
has mentioned two employers of his of the claimants. He has mentioned two employer of the claimants. So you need to clarify which one is talking about. He said it, my lord. He even said he was engaged just like Tony was engaged. You need to clarify it, my lord, so that it won't be ambiguous. It won't create ambiguity.
My lord is not.
Is that an issue before this court? Who the employer of the witness is?
My lord,
is that an issue? Who the employer of the witness is?
No, my lord, of two employer or the witness. No, not only the witness. He said he was employed just like what's it called? He was employed by Bristol, just like Tony was employed. That's why. That's
I never asked any question about who employed Mr. Lawal Oseni.
I don't have such a question, Mr. Tunji. I don't know where you got your question from. I don't have that. Okay. Is that your only question?
My lord,
I'm overruling that question.
My lord, I didn't ask who the employer of Mr. Lawal Oseni, the witness, is.
I don't have that question in my records too.
I said you were talking about employer of the claimant. It's not about his own employer. It's talking about employer of the claimant. And here now we're talking about two employer for the claimant. Which one is he referring to? We are talking about Sisado. We are talking about Bristol. Even the claimant is claiming that Sisado is his employee, is his employer. But the witness said Bristol is his employer.
Well, that is not an issue before the court. I don't think the claimant came to court for the court to determine who his employer is. He came for claims of entitlement.
It's very important because in that letter, that was why I was saying.
Is that the case of the second defendant? The case of the first defendant?
I'm sorry,
is that the case of the first defendant?
Yes, my lord. Yes, my lord. Yes, my lord.
Okay. So the witness is discharged from the box.
As court please.
The defendant applied that his case his defense be closed, my lord. No more witness to call.
Okay. The case of the first defendant is closed today, the 3rd day of June 2026.
As court please.
Adija, give us a date quickly for continuation of trial.
My lord, 22nd July.
22nd July.
Second.
What day is that? 2/2.
Yes, my lord, a Wednesday.
22nd July is convenient, my lord.
I just hope the court will have gone on the vacation at that time.
The circular is not out.
At the court places. We want to be on the safe side, my lord. I will not take a day that way, partaken by offense.
If the circular comes out and there's a conflict of date, we'll get back to parties.
As a
but for today, let's agree on the date. 2 July. Is that okay?
It's convenient to me.
Okay. So case adjourned to 22nd, 2 July 2026 for continuation of trial.
As court please.
It shall be a physical meeting, right?
Huh?
We applied for virtual trial.
It's virtual.
Okay.
Yes, my
no problem. Zoom details will be shared to parties then.
As court please.
Okay, you can leave the meeting then.
Thank you.
And the court please. Thank you, Manuel.
Thank you. Adija, is this the last matter?
Yes, my lord, that's not for today.
Okay.
Leave the meeting.